I beg to mention item number 6, Lordship. Yesterday, we filed an adjournment with Lordship.
Item number 6.
6, Your Lordship. Obliged, Lordship.
Yes, Mr.
Lordship, I beg to mention item number 9, Lordship. I have taken the consent of Mr. Hazarika on the other side. If it can be after the vacation, Lordship.
What do you want?
Uh, four- 14th November, if it can be accommodated, Lordship. First week, I will be in outlying benches, Lordship. I'm obliged, Lordship.
May I please, Your Lordship? Lordship, item number 8. I beg to mention that item number 8 may be taken after.
Item number?
8
Huh.
may be taken after vacation.
After vacation.
Yes,
Why?
my lord. The file is not totally prepared. We are not prepared actually.
2019 matter.
May I please, Your Worships? In Team Order is page 54. In this case also led to Bhutar because in the 1997 in the Bhutar list, Lordship, that is Lordship's first page 61, Lordship, Enquiry Report 61. Petitioner is Ataur Rahman. Father's name here not mentioned. Other documents mentioned, Lordships. Address Gorbita, Lordship. State of Assam, so and so. Lordships documents. Next page, Lordship will find Annexure A. First one is form of reference by competent authority, SPD board, Superintendent of Police. Next, page 62, Lordships. The reference forwarded to the electoral registrar officer after enquiry. In the enquiry report, Lordship will find my name also mentioned, my father's name mentioned, column 3, Hikmat. My date of birth here mentioned, Lordship 65, but I born on 31/12/1967. I have a school certificate also. And next, Lordship, almost paper is blank. Nothing mentioned. Therefore, no enquiry at all in the case, Lordships. The basis of these, Lordships, it was forwarded to the Foreigners Tribunal, Lordships. Page 65 is the forwarding report, Annexure B. Regarding deputal Lordships, here stated that whereas the Election Commission of India has ordered intensive revision of electoral roll for 44 Jonia Assembly constituency in Assam with reference to 197 as the qualifying date. And whereas house to house enumeration was done during the period from 6th January 1997 to 15th April 1997, whereas the name of Sri Ataur Rahman, son of Hikmat, who is declared to be an Indian citizen and also an ordinary resident of village Gorbita, has been enumerated for inclusive in the draft electoral roll. And whereas the election roll of said constituency was published in draft electoral roll of 24 July 1997, including herein the name of the petitioner Ataur Rahman. The bottom, Lordship, will find based Annexure A, that Lordship, that is almost blank, no enquiry at all Lordships, local verification done by the science officer, Bangalore, ERO. Okay. On that basis, suspecting Lordships. And according notice was issued, I entered appearance submitted by WS, written statement. WS is at page 45. And not prior to that lawsuit notice, page 43. Page 44. In the notice, no stream also mentioned, or this shall not be, whereas this case has been registered against you in view of allegation made by superintendent of police, and here it is to inform you that so as to file shall not declare for in between 1/1/1966, 25/10/1 after 25/6/21 under provision for nurse. Barnacular lawsuit fine, page 44. On receipt of notice, I entered appearance, submitted written statement. Details of my family stated, place of birth. Details I have lordship stated. My family tree, father's name, mother's name. Their names enter in the brutal list also. And my name also, I also stated along with my father's name appeared. In this case, state neither appeared nor adduced any evidence also. One court witness, I adduced evidence, court witnesses, Gaur also adduced evidence. And then if you know that I find lordships, no findings at all, only discussions regarding the brutal list, why I have not produced other brutal list, but no findings at all given by the learned tribunal regarding my statement, evidence, everything's in the documents also. What I have produced, that has been also only statement. So it is a case of remanding lordships, since no findings given by the learned tribunals at all in this case. And no inquiry also at all done by. Lordship may direct SPV to make an proper inquiry in this case, and tribunal decide on the basis of my evidence and records. I will also relied upon some distance of the Honorable National Court as well as the respective lorships. My father's name appeared in the Jamabandi of records 19 Jamabandi of the year Sita lordships, not Jamabandi Sita. 58 to 65 the land. My father's and my uncle. My uncle's name appeared in the brutal list of 1966. And father's having a family card also. There is a government document. I also produced a school certificate. There's a government document receipts. And my father's mother NRC legacy data of the year 66. I had produced as exhibit A and B. Not dispute at all that my father says a hikmat, and the inquiry report they on their own also admit on the basis of brutal list hikmat. And my first name appeared in the brutal list of 1985. I had cast my vote, and I was also contested the election also, Lordship, I am group member Panchayat elections in the year 1990. The details has been stated in my written statement. Page 35, your Lordship will find, along with my father's, my name in the brutal list. Evidence.
Yes, Mr. Sharma. What do you have to say?
Lordship, here Lordship will kindly see page 31. Here projected uncle's name appeared Lordship Ismail Sheikh, 1966 Futaralist Lordship, and Moijan Nessa Lordship. After that Lordship, in any other Futaralist Lordship, these persons are come along with the projected father of the petitioner Lordship. Apart from that Lordship, petitioner casted first time vote in the year of 1985 Lordship. And as per school certificate page 27 Lordship, his date of birth is 31/12/1967 Lordship. And if he is born in the year of 1967, then how his name can appear in the voter list of 1985 Lordship? And if he is born in the year of 1967 Lordship, at that time Lordship, legitimate age of casting vote was 21 years Lordship. And if we consider date of birth Lordship, then in the year of 1985 Lordship, his age would be around 17 years Lordship. Apart from that Lordship, school certificate was not proved. And as a linked document Lordship, Gaubura certificate has been produced before the tribunal Lordship, and Gaubura come to depose his evidence before the tribunal. Lordship. And if we see the deposition of Gaubura, Lordship, he was 32 years in the year of 2017, Lordship. So, what deposition he has given, Lordship, is a hearsay evidence which has no value, Lordship. And Lordship will kindly see the 1985 footer list, page 35, Lordship. Hikmat Ali is the projected father, aged about 35 years. Moiful Nessa is the mother, projected mother, and Atwar Rahman is the petition proceeding. Lordship will see the age of the Hikmat Ali, aged about 35 years. Moiful Nessa 28 years and Atwar Rahman 28 years. Age difference between
Which
mother
document
and
you are
son,
saying?
Lordship. 36 page number.
Voter list of
1985, Lordship. First time his name appeared, Lordship. What's his name? As well as his father's name, Lordship. Lordship will see, kindly see the age difference, Lordship. Mother is aged about 28 years and Atwar Rahman Prosidi is aged about 21 years. So age difference between mother and son is 7 years, Lordship. And although Hikmat Ali, Lordship, projected father of the petitioner, Lordship, aged about 35 years, before 1985, Lordship, is never casted vote. And no voter list has been shown by the petitioner, Lordship.
from the record, what we have seen is that particular voter list was not exhibited.
Yes, Lordship, that was not exhibited. And no, after only 1997 voter list was exhibited, Lordship.
That's right.
Yes, Lordship.
That's right.
Then, Lordship,
97, 2010.
in between voter list was not exhibited, Lordship, before. And after in the year 2008, Lordship, petitioner and his father's name suddenly appeared, Lordship.
Where?
2008, Lordship. After 1997, Lordship, 2008 voter list has been placed before this court, Lordship.
No, it has not been exhibited.
Yes, Lordship.
It has not been exhibited, so we are not considering that.
And Lordship, in 1966 voter list, Lordship, page 31, it is of village Muhia. And other village is of village Chitapani, Lordship. So there is a shifting, and regarding shifting, Lordship,
Everything stated in my W, shifting,
shifting.
everything's details are there, family tree
Only
details.
statement is not enough, Lordship. He has to prove his shifting, Lordship.
Lordship, I'll submit there.
Regarding Lordship, enrollment of name in the voter list, Lordship, I want to rely on a decision of this honorable court, Lordship. WBC 7340.
No, name of the petitioner not reported in any voter list.
Yes, Lordship.
So whether his name is there or not there, how it materials,
Yes.
how it matters.
No, Lordship.
So. Me. Which one like to place? Who is that judgment?
7340/2016. Afroza Begum versus Union of India.
7340.
Yes, Lordship. 2016. Para 9.1. Para 9.1.
Just a minute, let's get it. Two thousand sixteen.
Yes, Lordship.
Just 1. Just 1. Afuza Begum.
Yes, Lordship.
Hmm.
9.1 from fourth line, Lordship. But we find that but it
9 point?
9.1, Lordship.
There is no 9.1. Okay, yes, there.
Yes. Okay.
Hmm.
From whatever was stated in the written statement, what is discernible is that according to the petitioner, Dul Mahmud was her father who has cast his vote in 1966 from Sutia constituency. Thereby, he was a citizen of India. Being his daughter, petitioner was thus a citizen of India. But we find that nowhere in the written statement there was any affirmance asserting that father was a citizen of India. It is a settled legal position that mere enrollment of the name in the voter list and long stay in the country is no proof of citizenship. Lordship. Although he relies on a voter list of 1966 projecting Ismail Sheikh and Moijan Nessa as her father, Lordship, as her uncle and auntie, Lordship, but in subsequent voter list, their name has not been enrolled, Lordship. Not a single voter list has been placed in respect of these two persons, Lordship. And Lordship, I want to rely on decision of Supreme Court judgment, Lordship, 2010-13 SCC 336, Lordship. 2010-13 SCC 336.
What do you want to show from this?
Lordship, regarding certiorari jurisdiction, Lordship, what Supreme Court has said, Lordship.
Oh, that one.
Santalal, Lordship. Para 28.
that was discussed in the Muslim Mandal.
Yes, yes, Lordship, Muslim para 112, Lordship.
Here para 28.
Yes, Lordship.
Yes.
The High Court ought to have considered that it was a writ of certiorari and it was not dealing with an appeal. The writ of certiorari under Article 226 of the Constitution can be issued only when there is a failure of justice, and it cannot be issued merely because it may be legally permissible to do so. There must be an error apparent on the face of record, as the High Court acts merely in a supervisory capacity.
Please take your seat.
An error apparent on the face of the record means an error which strikes one on mere looking and does not need long drawn out process of reasoning on points where there any conceivably be two opinions. Such errors should be not require any extraneous matter to show its incorrectness. Such errors may include the giving of reasons that are bad in law or inconsistent, unintelligible, or inadequate. It may also include the application of a wrong legal test to the facts found, taking irrelevant considerations into account and failing to take relevant consideration into account, and wrongful admission or exclusion of evidence, as well as arriving at a conclusion without any supporting evidence. Such a writ can be issued when there is an error in jurisdiction or authority whose order is to be reviewed has acted without jurisdiction or in excess of its jurisdiction or has failed to act. While issuing the writ of certiorari, the order under challenge should not undergo scrutiny of an appellate court. It is obligatory on the part of the petitioner to show that a jurisdictional error has been committed by the statutory authority structure. That's all.
But here, what is the claim? Claim is that the learned tribunal did not discuss the issues which are placed before the tribunal by the written statement and the documents that was exhibited before the tribunal.
Lordship.
Of course, at the same time, Mr. Borgoya also placed that the inquiry report was not complete.
Lordship.
Right? That's what is his claim.
Lordship.
Now tell us, from the reading
Lordship.
of the opinion of the tribunal, do you think that the tribunal has discussed all the issues that was raised before the tribunal by the petitioner or by the proceeding?
Yes, Lordship. Enquiry report, Lordship, it is, Lordship, LVO based on police has not conduct inquiry in this case, Lordship.
That is
This
the-
is based on ERO's report, and
Right.
what ERO has given, Lordship, is LVO report is not satisfactory, Lordship. Then ERO send the concerned superintendent of police for reference of this case. And that is why, Lordship, in this case also ERO has not satisfied with the report of the LVO, Lordship. That's why he has sent the to concern sent it to concern superintendent of police, Lordship, and it was accordingly it was transferred to concern foreign tribunal for opinion, Lordship. So, Lordship, and petitioner getting enough scope to prove his case before the tribunal, Lordship. And regarding discussion, Lordship, I think, Lordship, everything has been discussed, Lordship, in this opinion, Lordship. Exhibit A is the NRC legacy data. NRC is not admissible evidence, Lordship. There is a after that, Lordship, 1966 voter list. draft CITA, family identity card, high school certificate.
What about the draft sitter?
Regarding draft CITA, Lordship, tribunal has not discussed, Lordship.
Then
Yes, Lordship, regarding draft CITA, Lordship, Exhibit A, page 58, Lordship. Tribunal has said only that Lordship draft CITA Exhibit is the draft CITA copy, but no other land document submitted connecting to this document, Lordship. Exhibit F, ration card is not admissible, Lordship. Nineteen 66 voter list also discussed, Lordship, where proceedings uncle and auntie's name appeared, but no other voter list submitted by the proceedings of his uncle and auntie, whom proceeded projecting as his relatives, Lordship. Exhibit INJ 1997 and 2010 voter list, where proceedings mother name appeared, where mother age is shown as 53, 65 years, but no other voter list of his mother or father submitted prior to 1997 voter list. Moreover, proceeding failed to submit voter list of his father. Proceeding submitted voter list of 1985 as Annexer I, where his father is shown as 35 years. It means proceedings father born in the year 1950, and he is eligible to cast vote in the year of 1971. Now the question arises, where the earlier voter list of his father, there was no explanation about it, Lordship. And WS is at page 45, Lordship. Where his father's name is not reflecting prior to 1985, there is no mention about this, Lordship.
nineteen 97 voter list was exhibit I.
Lordship.
It was submitted as an Excel, but
Yes,
not
Lord.
exhibited.
Yes, Lordship.
So do you think that discussion was again? Now regarding the land document.
Yes. Regarding land document lordship, here only one line has been said. Elaborate discussion was not made, lordship. Exhibit E draft sheet copy, but no other land document submitted connecting to this document, lordship.
Not necessarily,
Yes, lordship.
because of that thereafter you have to pay the revenue payment receipts.
Yes.
Whether the petitioner is in possession of the land, all this thing has to be placed before the tribunal. Only mere producing it will not do. Now come to the land document. Mr. Bornea as well as Mr. Sharma.
Lordship.
Page 20, Lordship.
Come to page number 19. Total land was 4 acres, 3 quarters, 6 lesses.
Yes.
In the name of Ismail and Hakmot, right? The
Lordship.
village of Borvita. That number 400. And it was Actiona,
Yes,
right?
lordship.
That was in the year,
1985.
no.
5865. It has land.
Page number 19.
Lordship. Lordship.
তিতাপানী মৌজাৰ বৰভিঠা গাঁৱৰ 5866 4খন নম্বৰ নাগৰ ভূমি চিঠাৰ নকল, right?
Yes, Lord.
That number 400. An area is 4 acre, 3 quarter, 6 lessers.
Hmm.
It's not legible whether 4 acres, 3 quarters or 4 acre, 4 quarters. Anyway, it was in the name of Ismail and Hakmot, son of Ramzan Sheikh. It was Actiona. Then come to page number next.
Whom year, Lord?
58 to
Earlier it
65.
was 4 bigha, 4 quarters, 6 lessers, right? Probably it was 4 bigha, no, 4 bighas, 3 quarters. One line is there. Now, the number is 341. Again, same area, 58 to
65.
65. Earlier, there's what, Kheras? There cannot be Kheras Sena. There it should be Actiona or Kheras. And now the land has become 3 quarter, 3 acres, 4 quarter, 6 lessers. In the name of, this is a different DUG number.
No.
In the record, There is another document. Same land. First page and second page is same. Not second page. There is a specific remark. উত্তৰাধিকাৰী সূত্ৰে পট্টাদাৰৰ স্থলত ইছমাইল and হেকমত পিতা স্বৰ্গীয় ৰমজান শেখ. But the document doesn't show when that order was passed
No.
by the circle officer. There is no specific order by which the names have been reflected. Anyway, that tag number 400.
Lordship.
If you see 400, then you will see 300 and 301
Yes,
by 217.
yes,
The same page, if you see here, the next page at page 21, it has become 341. Tag number 341,
Mm.
191, that's 278. 191 by 274.
274.
But here is clearly written 3 vigas, 4 quarters, 6 lessons.
Mm.
Then there is another document here in the record. It was in the name of Hekmot Ali. নামজারি নোহোৱা দখলকাৰীৰ নামৰ, that is Hekmot Ali, Peter Ramzan Ali. But there is no mention about the area of land. So probably the particular land was in the name of Ismail Sheikh. Petitioner, the proceeding did not place all the materials or did not clarify these materials
Yes, sir.
before the term. Sharma? Yes,
Lord, this land document is of year 1958 to 65, Lordship. If there existed prior to 1965 at village Titapani, Lordship, why there is them not enlisted in the voter list of village Titapani prior to 1966? They relied on a voter list of 1966, Lordship,
of
of
Ismail
village
Sheikh.
Ismail Sheikh of different village, Lordship, Muhia, Lordship.
But that village is Borbita.
Borvita.
This is the last page of the land document. There at the top, you will see the vernacular. That name of Hekmat Mali was not. No, that you will see there.
Yes, Lordship.
Namjari Nuha.
Yes, Lord.
750.
Namjari Nuhua.
দখলকারী নাম।
নামজারি নুহা দখলকারীর নাম। So that means Lordship is enforcing this land, Lordship.
That is also the previous page you will see. In the name of instead of Ramjan Ali, Uttoradhikari Hutre.
Lord.
Two names are there, Ismail Sheikh and Hekmat Ali.
Yes,
But there is no such order by which their names have been
yes.
incorporated in that land. Show it to Mr. Borvi. Those four particular pages.
That's one of the document Lordship, that Lordship. It is entered in the clear in the photocopy also. It is entered in the page.
It's there because whatever documents you have exhibited, we will not go beyond that.
Lordship
So you see that from the records,
is that
Mr. Sharma showed
1997. Question is that Ramjan is not in dispute. Hikmat is not in dispute. We should drag as a whole document, not as a piecemeal. My learned friend says
Mr.
age.
Boromir.
Lordship, my learned friend
We
showed
are not on
only
that.
age. Question is that
See, Mr.
we,
Boromir.
my father's parent, Lordship, yes, agree with the Lordship. My case is that if regarding foreigners case, Lordship, whether the concerned persons are between prior to 1966 or in between 162 or 25 to 66, there is the question. And here is that they are not in dispute in my father. They are not dispute in my grandfather. Their names appear in the documents as a particular village. Only when disputing 1997, D has been marked. That's why in putting D, certified copy issued other family members, discarded my name. In the 1997 Lordship Buddha list, will find one name is not entered because due to insertion of D, that certified copy not entered.
Why the name of the father of the petitioner did not
Here-
figure? Why the name of the father of the petitioner did not figure in the voter list of 66 and 70 or thereafter? Why only in the year 1985?
Lordship, yes, I produced Buddha list 1985.
Why not before?
Certainly were advised the council not produce, but must have a Bhutan list because
If you have If the
Today
name-
I
if
do
the
not
name
have,
of the father of the,
today I do not have,
listen.
Lordships.
If
Your
the name of
Lordships,
the father of the petitioner was incorporated in the Federal List of 1970
that does
or
not,
thereafter,
Lordships.
prior to 1985,
my lord, my
produce the
submission
certified
is
copy.
that
you produce the
entering
certified
the
copy.
name of the persons in the brutal list cannot claim a citizen. Question is that person is a citizen of India or whether any document having prior to 1966 or in between. Here is the document, land document, very much clear. The document of 58 to 68.
Where is the land revenue paying receipt?
That
You have been occupying that
question is
land.
not land, not in disputing in land. Lordships, hear me, Lordship, not in disputing the land. Not I have having how much land I have. This is not a case
It is-
of the response.
Listen, it is your
First party,
document.
Lordship.
Listen,
Lordship, at least bear me. We have
don't go
to,
to that extent, Mr. Borby.
Lordships,
If you become more technical and critical, you will be in trouble.
Lordship. But
Many things you
question is,
talked up.
no,
Listen,
Lordship,
listen.
they have to inquire, proper
First of
inquiry,
all,
Lordship,
That then document which you have exhibited
Lordship,
is very clear. Is very clear.
Lordship.
Mr. Sharma, show him what is there in that
Yes,
land
Lordship.
document. That is your document. You have exhibited. It's not the other side.
नामजारी नहीं हुआ दखल करे
So how can you have any force on that particular land document?
नामजारी नहीं हुआ
Namjari Nuha Dakhalkari Nam means what? Introducing some land. So it is your document to show whether you are
Nam.
a legal heir of Ramzan Ali or not. There is no order.
yes
See that there has to be an order of the circle officer by which your name should have been there in place of Ramzan Ali. If it is, you are a legal heir. There is no order.
We applied, enter on name.
Entering your name is fine.
Yes, on the basis of
But thing is
document.
this.
Yes, on the basis of document.
This land document,
Lordships,
list particular land document doesn't show any order of the circle officer by which your name along with Ismail Sheikh has been entered in the land document of Ramzan Ali as legal heir of Ramzan Ali. There is just verify from
yes,
your
I verified, Lordship.
find out if you can show us.
No,
we
Lordship,
will consider.
that document issued by the authority. It is their duty what are to be written, what are not to be written.
Tell
Lordship,
us, tell
I
us,
applied. They have to
Mr.
verify it.
Mr. Brovia,
They,
Lordship, it is your land.
yes, I am not this Namjari Nuha. That means, Lordship,
दखल करे
at that time, no
Show us by
names,
which order
by
your name
which
has
order?
been incorporated.
they have not mentioned.
Will you
Lordship,
listen to us? Show us
today, Lordship,
from that particular exhibit which you have placed before.
your
the
Lordship,
tribunal.
give me time. I will apply for the same on which order they have issued. Is a available order in the office of the circle officer.
It
They
should
have to
placed-
start.
it should have
Authority
placed-
should have read on by
Who is supposed
order
to-
so and
Who
so.
is supposed to prove? Who is supposed to prove? It is your case, you are supposed to prove it before the tribunal. Now, this particular exhibit clearly reflects there is no order of the circle officer by which you could have been shown that you are the legal heir of Ramzan Ali.
Tribunal also failed to make any.
Not required. It is your
Lordship
case.
required. I tendered my evidence that has to be discussed. Without discussing anything, Lordship, how
First
the
of all,
tribunal,
From this exhibit, the
Lordship,
records are before
not
you.
only, my school certificate is also available.
Have
Then,
you- have
no,
you,
yes,
have
even
you
if,
proved it by
yes,
the
Lordship,
headmaster?
even
no
if,
no
Lordship, even if school certificate is not required to prove, as per the Supreme Court decisions, I will place the decisions.
School certificate.
Yes,
is not
I will,
required
I
to
am
be
placing.
proved.
That
Please
can't,
listen to us.
at this, they just can't raise any objection. It is, objection is the very entry. When I adduce, when I tendered my evidence, they have not objected it.
That,
I am placing. No,
that
Lordship, I
case
started.
relates to the citizenship or that case relates to NRC? The judgment of the Honorable Apex Court?
I am placing judgment lordship what to be there after adducing my duties, what are the duty of the state, what to be discharged, what to be not. I discharge my burden. I give evidence, and the documents standard, no findings at all.
So what
There
the
is no
judgment?
inquiry at all. There, my learned friend Simon has
Source.
projected.
Source.
Authority stated, I am the son of sons of
Supreme
my,
Court-
my father not disputing, my grandfather is not disputing. Only one family, how can be lordship?
Show us.
Lordship.
that
Yes,
judgment.
your lordship, first I am placing the judgment of the Honorable FS Court, Sarvanda Sonwal, 2007. What are their duty? 2007 1 SCC 174, Sarvananda Sonwal 2. Lordship, paragraph 50.
Paragraph.
First, paragraph 50, may I read? Principle of natural justice indisputably is required to be complied with before a tribunal passes an order of deportation. The 1946 Act and the orders framed thereunder contain inbuilt procedure. The procedures laid down therein are fair and reasonable only because the burden of proof is on the proceeding. The saying by itself would not mean that the proceeding is ultra vires the provisions of Article 21 of the Constitution of India. Article 21 would not be offended if the procedure is fair and reasonable. Then let's come to page paragraph 55. There cannot, however, be any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who claims himself to be a citizen of India in terms of the Constitution of India or the Citizenship Act is entitled to all safeguards, both substantive and procedural, provided for therein to show that he is a citizen of India. Then then 60. Having regard to the fact that tribunal in the notice to be sent to the proceedings is required to set out the main grounds. Evidently, the primary onus in relation thereto would be on the state. However, once the tribunal satisfied itself about the existence of grounds, the burden of proof would be upon the proceeding. Then Lordship 62. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence, his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on this point, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. Lordship, they are not disputing any of the documents. They have not discharged their burden after giving evidence. Then Muslim Mandal Lordship. Muslim Mandal Face Lordship. 2013 1 GLT 809.
Yes, please.
Paragraph 93, Lordships. Last time we have paragraph 93. Then 94. I am reading Lordships. Paragraph 93, may I read, Lordships?
94.
93. First, I am reading first 94. The right to get a fair trial, Lordships.
Yes, yes, please.
The right to get a fair trial is a basic, fundamental, and human right. Any procedure which comes in the way of a party in getting a fair trial would be violative of Article 14 of the Constitution. Fair trial also includes a fair investigation. The concept of fair investigation and fair trial assumes much importance in the matter of detection and deportation of foreigners under the provisions of the Foreigners Act 1964 order as well as 2012 Amendment order because of the nature of proceeding as well as the burden cast on the person who is suspected to be a foreigner to prove that he is not a foreigner by Section 9 of the 1946 Act. The citizenship right is to be jealously protected. The right under Article 21 of the Constitution is available to all persons to protect his life and personal liberty, and hence, even the right of a non-citizen to have fair investigation, trial, as well as fair procedure to be adopted by the tribunal is guaranteed by Article 21 of the Constitution. Then paragraph 94. The FS Court in Darka Prasad Agarwal Supra has opined that right to get a fair trial is a basic fundamental human right, and denial of fair trial violates Article 14 of the Constitution. In Jahir Habibullah H. Sheikh Supra, commonly known as Best Bakery case, the FS Court, giving emphasis on the principles of fair trial, has opined that just application of its principles in substance is to find out the truth and prevent miscarriage of justice. It has also been opined that concept of fair trial entails the familiar triangulation of interest of the accused, the victim, and society, and it is the community that acts through the state and prosecuting agencies. It has also been opined that a trial which is primarily aimed at ascertaining the truth as to a fair to all concerned, it will not be correct to say that it is only the accused who must be fairly dealt with. That would be turning a Nelson's eye to the needs of society at large and the victims or their family members and relatives. Public interest in the proper administration of justice must be given in much importance, if not more, as the interest of the individual accused. While dealing with the role of the court, the FS Court observed that the courts have a vital role to play. Its role is to discover, vindicate, and establish the truth, and hence the trial should be a search for the truth and not about technicalities. The FS Court further observed that the presiding judge must cease to be a spectator and a mere according machine, and he must have active interest and elicit all relevant materials necessary for reaching the correct conclusion to find out the truth and administer justice with fairness and impartiality both to the parties and to the community. Next, paragraph 95. In Jahir Habibullah's essay, the FS Court opined that every state has a constitutional obligation and duty to protect the life and liberty of its citizens, which is the fundamental requirement for observance of the rule of law. There cannot be any deviation from this requirement because of any extraneous factors like caste, creed, religion, political belief, or ideology. The FS Court further opined that the fair trial consists not only in a technical observance of frame and forms of law, but also in recognition and just application of its principles in substance to find out the truth and prevent miscarriage of justice. In Samadhan Duduka Koli Supra, the FS court has reiterated its view that prosecution must also be fair to the accused. Fairness in investigation, as also trial, is a human right of an accused. In Himanshu Singh Sabarwal Supra, the FS court, reiterating the earlier view, has further opined that the fair trial is inherent in the concept of the due process of law, and the fair hearing requires an opportunity to preserve the process. In Nirmal Singh Pelon versus State of Punjab and others reported in AIR to the 9 SC 984, the FS court has reiterated that fair investigation and fair trial are concomitant to observance of fundamental right of an accused under Article 21 of the Constitution. And hence, though the state has a large obligation, that is to maintain law and order, public order, and preservation of peace and harmony in the society, a victim of a crime thus is equally entitled to a fair investigation. In National Human Rights Commission Supra, commonly known as Godra riot case, the FS court has reiterated the requirement of having fair investigation and trial. Then regarding inquiry lordships, 96 paragraph. One of the contention of the proceedings is that though the referral authority is required to make the reference to the tribunal after making a fair investigation, no such proper and fair investigation is conducted, and the police at their own whims and caprice gives a report. In some cases, even without visiting the place where such proceeding resides, and also without giving any opportunity to produce the relevant documents to substantiate that the proceeding is not a foreigner, and such a report is accepted by the referral authority, and accordingly the reference is made to the tribunal on the basis of which the reference is registered against such persons. And 97 is also important. Paragraph 97. Fair investigation and fair trial being the basic fundamental human right of a person, which are concomitant to preservation of the fundamental right of a person under Article 21 of the Constitution. There has to be a fair and proper investigation by the investigating agency before making a reference to the tribunal. In such investigation, the attempt has to be made to find out person against whom the investigation is made, so that person concerned is given an opportunity to demonstrate at that stage itself that he is not a foreigner. In case the person concerned could not be found out, that this different regarding not finding, then placeable paragraph 98. The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigation officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording in satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during investigation before the tribunal, as the tribunal is required to prima facie to satisfy itself about the existence of the main grounds before issuing the notice to the proceeding. Here is the case, lordship. In the initial that reference made, that is no inquiry at all, only name and address, my father's name mentioned. And the documents which I also been produced, it was not challenged and not debuted. The document of the land document containing my father's name, my uncle's name, my grandfather's name. And the inquiry, the so-called inquiry report, the tell my name, my father's name mentioned. I am the son of Hikmat. And all the documents containing my father's, mother's family members, they have not debuted, not disputed at all the documents which I have placed before the tribunal. At this stage, lordships, And I also produced being the son of Hikmot. Hikmot is not in dispute. My grandfather is not in dispute. Then what disputing? Some brutal list I have not been placed. So the tribunal declared that I am the foreigner. But the documents which I produced, there is no findings at all mentioned that that is false or it is not relating to my father's or along with my records. I am lordships another regarding school certificate. That is 2009-12 SCC. Page 454. Two 2009-12 SCC, page 454.
Yes.
Paragraph 20, 21, 22. Paragraph 20, Lordship. May I read? Evidence Act of 58, section 58. Lordship got it. 2009-12 SCC 454. Shamlal alias Kuldeep.
Shamlal versus.
Shamlal versus Sanjeev Kumar and others. Paragraph 20, 20. The High Court also observed that since the onus to review the presumption was on the defendants, it was for them to prove the plaintiff and defendant are not the sons of the deceased. Section 50 and 60 of the Evidence Act cannot be pressed into service by the defendants to contend that the plaintiff has failed to prove his relationship with the deceased Balak Ram. Then paragraph 21. One of the documents relied upon by the learned district judge in coming in the conclusion that the plaintiff is the son of deceased Balak Ram is Exhibit P2, the school living certificate. The learned district judge, while dealing with these documents, has observed, on the other hand, there is a public document in the shape of school living certificate, Exhibit P2 issued by the headmaster, Government Primary School, Jabal Jam Road, recording Kuldeep Chand alias Shamlal to be the son of Sri Balak Ram. In the said public document, as such Kuldeep Chand alias Shamlal was recorded as son of Sri Balak Ram. The findings of the learned district judge holding Exhibit P2 to be a public document and admitting the same without formal proof cannot be questioned by the defendants in the present appeal, since no objection was raised by them when such document was tendered and received in evidence. Paragraph 23. Paragraph 22. It has been held in Dashananda Singh versus Jalam Singh that an objection is to be admissibility of mode of proof if a document must be taken at the trial before it is received in evidence and marked as an exhibit Even otherwise, such a document falls with the ambit of Section 74 Indian Evidence Act and is admissible per se without formal proof. Lordship, documents I placed, they have not objected anything, even discuss every document, Lordship. Then my evidence standard also not been refuted also, Lordship. May I rely upon the decisions? And next, another, Lordships, regarding evidence at 2009 11 SCC 545.
Yes.
To the 11 9 SCC 545. Seth Ramdoyal Jet versus Lakshmi Prasad.
Yes. Yes.
Yes. Mm, Seth Ramdoyal Jet versus Lakshmi Prasad, paragraph 22, Lordship.
22.
22, yes, Lordship.
Yes.
Section 58 of the Indian Evidence Act. Read as in the facts admitted need not be proved. No fact need to be proved by any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleadings in force at the time they are deemed to have been admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by and such admission. In view of the aforementioned provision, there cannot be any doubt or dispute that the things admitted did not be proved. See Vice Chairman Kendriya Vidyalaya Sangathan and another versus Gridori Lal Jadhav 24/6 SCC LK so and so case. Over the case referred to. The regarding admission of fact or admission of documents, Lordships. They are not in dispute. They admit it amounts to admission. Evidence.
Mr. Borgia, one thing I'd like to point out, both the judgments which you have cited last of the Honorable Apex Court,
Offers or Lordships
of the Honorable Apex Court, if you see,
are
relates to decision in an appellate stage. Relates to appellate stage. Both the decisions which you have cited. There the Honorable Apex Court has considered, if you read the background of the case, whether the 2009 12 SCC 454 or 2009 11 SCC 545, you will see that the Honorable Apex Court found that at the appellate stage, such evidence is not to be accepted because it was considered at the early stage. Right? But here, as you know, to what extent foreigners tribunal is required to accept the evidence to be adduced by a proceeding under the provisions of the 64 Act, under the Citizenship Act, or the Foreigners Act of 1946.
tribunal
So-
power as jurisdiction civil court, Lordship, as
Is
per
it?
46 says.
Okay. But whether any such document, just by mere pressing the document will be enough without leading to the evidence. I
I-
think our High Court have passed some orders in that regard
I adduced evidence, Lordship.
with regard to your school certificate.
School certificate, Lordship, they are not disputing. I placing my name, not disputing that document false. It is not
You might have
unless they
exhibited,
rebuted, Lordship.
you might have exhibited the school certificate. Whether the person concerned who issued the school certificate or the some school authority is required to adduce evidence or not.
Unless they objected it.
No,
Is it?
If they,
No.
whether any objection
Are you
made
sure?
at that, yes, at the time, objection is at the time of placing my documents.
So
What
according
about
to you-
objection?
According to you, your school
Then-
certificate only when is objected needs to be proved.
Objection is a government document. Is that this one Lordship says school certificate, the public document.
That particular school was what school?
That is school certificate.
Name, read the name, that
Yes.
particular paragraph, what kind of
Yes.
school it was?
School certificate, page 27,
That particular school in the.
is a,
Apex school
is a
judgment.
provincialized school. Inspector of school also put there his signature countersign. Lordship. Page 27, the school government school, public document. And headmaster is a public officer. Page 27 is the school certificate. Countersigned is there. Inspector of schools, Lordship, assistant inspector of school, Barpeta.
Yes, Mr. Sharma, Mr. Payam, what do you have to reply in this?
And other decisions I have, Lordship.
Come back to.
Lordship.
First of all, my lord, as my learned friend
Only
is-
come to the school certificate, now don't
Yes.
come to the others.
my lord, the
Because
school
what
certificate,
Mr. Borboy is saying, the land document as well as the school certificate
yes,
was adduced as evidence, it's remained unrebutted.
that issue I'm coming back. First of all, he has produced the my lord land documents of some other village. And they are claiming it in WS itself, they have said, my lord. their
No,
lords-
a person may be of one village, say you are a person living in Uzan Bazar.
Yes,
You can purchase the land of village Maligaon.
definitely, I have not done that, my lord. The first of all, my lord, what they needs to be proved. Because it is, my learned friend is arguing again and again that, my lord, it is not dispute that his father is citizen, his father is citizen. My lord, well, para 26 of the Savananda Sunat Supreme Court. One, it is said, my lord, what needs to be proved. They may required to be give evidence, give evidence, my lord, of numbers, date of birth, my lord, I don't know. Secondly, the place of birth. Third, my lord, names of the parents. And fourth is more important one, the place of birth and citizenship and their citizenship. Place of birth of parents and their citizenship. That evidence to that effect has to be bring by the petitioner. Whether they have brought any evidence to that effect in this case. Because that once he can prove that his father is a citizen of India, then only, my lord, the petitioner can claim that being son of so and so, I am also a citizen of India. That must has to be proved. So regarding date of birth, my lord, regarding the birth, this, my lord, school certificate, your lords will find from the very school certificate itself, page 27. This school certificate was issued by the headmaster on, my lord, 5th of April 2000. And as yes, and as per this school certificate, he studied in the school in 1985. 85, 95, 2000. After 15 years of gap lapse, the school certificate has been issued. That is a first issue. And secondly, my lord, this school certificate in Biratmal Singhvi, my lord, this is the Supreme Court judgment 1988, my lord. It is clearly said the school certificate has to be proved. 1988, my lord, this is 1988, SAPI SCC 604. Para 14 is relevant in this case, my lord, 1980. Sapti SCC, my lord. 604, Virat Mansi. Here in this case, my lord, there are 14, my lord. There are 14, my lord. 14, my lord, it starts. It's a big, my lord. I'm not going to read entire. Only part is, my lord, from page 618, my lord, last part. Page 618, last part. Last part, not as already stated, my lord, that from last part of the page 618. As already stated, neither of the parents of the two candidates nor any of the person
You
having.
are reading at paragraph 14 itself.
Yes, 14 in the last part, my lord. 14. It's a long paragraph.
The sentence starts with
As already stated,
on the left side,
yes, yes,
left side.
618, madam. Page 618.
No. The sentence on the left side starts with what?
My lord, recorded in the aforesaid documents, the documents.
Okay.
Number exhibit 8, 9, and 10, 8, 9, 10, 11, and 12 are relevant and admissible, but the documents have no evidentiary value for the purpose of proof of date of birth of Hukmi's son and Suresh Prakash Joshi, as the vital piece of evidence is missing, because no evidence was placed before the court to show on whose information the date of birth Hukum's son and the date of birth of Suresh Prakash Joshi were recorded in the aforesaid documents. In fact, my lord, in this case, school records, my lord, were also said that whoever given the information in the school record, he has to be examined. Up to that level, my lord, this has been done. My lord, as already stated, neither of the parents of the two candidates nor any of the person having special knowledge about their date of birth was examined by the respondent to prove the date of birth mentioned in the aforesaid documents, the school certificates. Parents or near relatives having special knowledge are the best person to dispose about the date of birth of the person. If entry regarding the date of birth in the school's register is made on the information given by the parents or someone having special knowledge of the fact, the same would have probative value. The testimony of Anantaram Sharma and Kailash Charan Taparia merely proved the documents, but the contents of these documents were not proved. The date of birth mentioned in the school's register has no evidentiary value unless the person who made the entry or who gave the date of birth is examined. That is important. The date of birth mentioned in the school register has no evidentiary value unless the person who made the entry or who gave the date of birth is examined. My lord, who made the
So
entry?
according to you, the document is proved.
Even in this case, my lord, document,
But here for the purpose of proving the contents, you
Yes,
have
ma'am.
to adduce evidence.
evidence. Even in this case, my lord, documents were proved. In this case, documents were proved. Documents was proved, but my lord, whether the
To prove
only
the
contents of the documents is proved or not. Because who can prove the contents of the documents? First of all, who has given the information? Secondly, who entered the my lord information? Only those two persons can. My lord, values, the date of birth mentioned in the school's register has no evidentiary value. Even the school register, not only the one school certificate, madam, school register, unless the person who made the entry or who gave the date of birth is examined. Unless this person, two person is examined, my lord, it cannot be accepted. That and this, my lord, this has been relied by this honorable court, my lord, in foreigners case also. This is, my lord, a case of this honorable court, my lord, This is WPC 3056 of 2018, my lord. 3056 of 2018, Onima Das, madam. This is disposed of on 3/1/2019. In this case, my lord, this particular judgment of the apex court has been relied on.
Three zero five six.
Yes, ma'am. 3056. Para 12 onwards, madam.
Yes.
From para 12 onwards. Its details discussion has been met, madam. The law as regard to the acceptability and legality of the certificate issued by the school authority had been considered by Supreme Court in judgment in Ram Suresh Singh versus Pravat Singh alias Suta Singh and others. This is 2009 6SCC 681. This is the relay, wherein it is in para 12 stated any entry in school register may not be a public document. Para 12, it is in that judgment, my lord, any entry in school register may not be a public document and thus must be proved in accordance with law, as has been held by the court in Biratmal Singhvi. But in this case, the said entry has been proved. In that case, it has. My lord, in Biratmal Singhvi has been, my lord, Biratmal Singhvi reported in 1990. This is, my lord, given. This is quoted again. Then para 14, again in respect of the certificate issued by school authorities, just a few days prior to the date of superannuation of person who had issued the certificate, a view was taken by the Supreme Court in paragraph 9 of the Union of India and others versus Kantilal Hematpre Pandey, reported in 1995 3 SCC 70. The documents appeared to have been brought into existence for the benefit of the pending proceeding therein, and therefore the concerned certificate was rightly not relied upon. From the aforesaid position, it can be called out that respect of the school records being produced as evidence, an entry of school may not be a public document and thus must be proved in accordance with law. That is the first point, my lord. Secondly, merely because documents pertaining to the school record have been exhibited and proved, it by itself does not mean that the contents of the documents were also proved. And mere proof of the school record which are exhibited would not amount to a proof of all the documents of the school record. So that is clear. The first of all, school record, school certificate has to be proved. Even then also, even thereafter also, even though the school certificate is also proved, it doesn't say the contents of the school certificate is proved. So two aspects. So this is clear. Further, there are more discussions, but this is
Okay. Yes, Mr. Murphy, please proceed.
so may I take a leave, madam?
Please.
92 seconds and it is section.
Which is the other judgment you say?
Lordship, I am placing regarding my learned friend regarding a school document says, Lordship, Indian Evidence Act 1872, evidence means. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. So Lordships, this case, I adduced evidence, and Lordships,
Yes.
that they have not disputed, they have not rebutted my statements. Nothing rebutted. Then section 4, what is the duty of the court, Lordships? Section 4 of the Evidence Act may presume whenever it is provided by this court that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Regarding my school certificate, Lordships, court also did not call for it. It is a public document. Public document is section 74 of the Indian Evidence Act, which are the public document. Section 74, public documents, Lordships, Indian Evidence Act, section 74. The following documents are public documents, documents forming the acts or records of the acts. Number 1, of the sovereign authority, of official bodies and tribunals, and the public officers, legislative, judicial, and executive of any part of India or the community of a foreign country. Public records kept of a private documents. These are public documents. So my learned friend, school records is not a public document, but here evidence says is a public document. The public officers kept. And regarding non-debiting my evidence, Lordships, and another evidence at Lordships regarding my land documents, section 90 of the Indian Evidence Act says, section 90. Presumption as to documents 30 years old. The documents, it was stated in the year between 1958 to 64. That beyond 30 years, the court presumes that is correct. Lordship, may I read the contents of the section 90 of the Indian Evidence Act?
Please read.
Lordship's presumption as to documents 30 years old, where any document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper. The court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. Lordship, the documents produced from the proper custody. The question raised before me that I been suspected before it. That documents, I claim my father's name, Hikmat, and they also in their initial entry of the enquiry, the so-called enquiry, there is no enquiry at all. My father's name mentioned, Hikmat. I'm the son of Hikmat. And that documents pertain in my father's name. So, and regarding presumption of document section 90, Lordship, may I relying upon the decisions of this honorable court?
So
Lordship?
which document is you are
And there's
talking about
to
the
the
land document?
Loan
Land
document
document presumption 30 years old.
30 years, that Lordships. Page 20. I read petition, Lordship. That is page 18, first one, certified from the draft sita of land in Dag number 400 for the period 5865 under Titapani Moja village Barpita. Dag number mentioned, land Russell has already gone through it. That is in the top appears this is the land of the period of the year 5868, where my father's name, uncle's name mentioned, their son of Ramjan Ali mentioned. And page 20 also, Lordship, that is also shown as 5865. That land, there's another land that is also in the records of Lordship. And in that document, Lordships, the certified copies appear that is an entry made in the 18558. In the signatures appears the certified
Page
copy.
number?
Lordships 58. Namjari Nuha. That is entry made in the year 1958. 18558, the bottom fine, Lordships. I have a clear copy. I think that that is not visible before your Lordship's copy.
You have not annexed that particular part.
Indeed, unfortunately, that has not been annexed, but records it is available. And Lordship, regarding my evidence in Lordship's first 2021 GLT. Yeah, Motiur Rahman. Motiur Rahman.
Yes, Namjari Nuha, what you have to show there? You want to showing some dates.
Lordships, yes, I have find there's the date if 18558, the signature part, Lordship, and so
18.5.
18558.
Here
Certified
there is nothing
copy
like that.
19385.
There
When
is a-
entry made, name entered of the person was Ismail Sheikh and Hikmat entered on 18558. That
It was a
Namjari
torn paper.
Lordship.
It was a torn paper from where the photograph was taken, it was xeroxed.
And that's
So there is. You verify? You verify? So something might crop up from the down below because the document was
Lordship.
torn. Mr. Sharma just checking off because we found that document was a torn one while making xerox or others. You see, sometime might crop from the page below
In page
because that
33,
document
Lordship.
was torn below. Yes, what do you like to show from this? Mr.
That regarding the documents, lordship, 30 years old document, lordships. So presumption can be drawn. These documents are correct as per section 90 of the lordships. So proper custody, if it is received from proper custody, then court presumes is a correct document.
Yes, yes.
And in this. And it is in section 90. And I am relying upon the decisions of our Honorable High Court Lordship 2007 2 GLT 399 regarding section 90 of the Indian Evidence Act.
2007 2 GLT.
399
Okay.
Bipin Chandra Kolita versus Sharma Kolita. Paragraph 22.
Two 2007 2 GLT.
Lordship, page 399. Party Bipin Chandra Kolita appellant.
Yes.
Paragraph 22, may I read?
There are 22.
22 lordships. A plain reading of the written statement of the respondents defendants reveals that no plea has been taken asserting that Jurai Kolita was illiterate and therefore was unable to read or write. In that view of the matter, the evidence of DW1 Sri Sharma Kolita to that effect cannot be taken note as a factor to deny the presumption for Exhibit 7. PW2 Sri Bipin Chandra Kolita appellant plaintiff proved Exhibit 4, whereby Champa Kolita had sold the suit land in favor of Gulapi Kolita. In cross-examination, this witness clarified that Srimati Gulapi Kolita had handed over the sale deed Exhibit 7 to him. He, however, deposed that the scribe and the witnesses of the sale deed had expired in the meantime. The said witness confirmed to have purchased the suit land from the Gulapi Kolita by sale deed Exhibit 1 and 2. BW Gulapi Kolita corroborated the sale of the suit land in favor of the appellant plaintiff Bipin Kolita. Having regard to the background of the transactions and the above evidence, the appellant plaintiff's custody of the sale deed Exhibit 7 is unmistakably proper and has to be accepted. The reservation expressed by the learned Lower Appellate Court on the production of the said document from the custody of the appellant plaintiff is therefore unfounded. In view of the clear and categorical testimony of PW2, that neither the scribe nor the witnesses of the said document are alive, the failure to examine them could not have weighed against the presumption under section 90 of the Act. The exception taken by the learned lower appellate court regarding the custody of the said document with the appellant plaintiff in absence of any statement of PW1 Srimati Gulabi Gultar to the said effect, in my opinion, is also of no avail. The evidence is one of the boundaries of the land involved, considering the time lag between the two transactions is also not of any significance. Here, my case is that document is 90 years old, custodian is proper, that custodian's name is their regarding father's name, uncle's name, place of residence, everything. And that is, they are not refuted that part. The court presumes the documents is having with the name of his father and uncle. And my specific statement that retains my father's name, uncle's names, grandfather's name, details are there. Written statement is very much clear, place of birth, area. Details I have stated as part of the substantial case that has to be first mentioned. In this case, I have mentioned lordships. And another documents, lordships, another discharge lordships. 2003 8 SCC.
Yes.
2003 8 SCC 752. CPC ko lang guys. Ito. Aji party bill. Parang sa tasin. Sa tasin. Cyber. Lordship got it.
Just a minute.
Lordship.
Yes.
2003 8 SCC 752. Paragraph 19.
What do you want to show from here?
Lordship, order 13, the documents I placed, no objection raised. So here, other side cannot raise any objection against the documents, Lordship. Order 13, Rule 4 of the CPC provides for every document admitted in evidence in the suit being endorsed by or on behalf of the court, which endorsement signed or initiated by the judge amounts to admission of the document in evidence. That is the language of CPC and the judgments on scholarships. An objection to admissibility of the document should be raised before such endorsement is made, and the court is obliged to form its opinion on the question of admissibility and express the same, on which opinion would depend the document being endorsed as admitted or not admitted evidence. In the later case, the document may be returned by the court to the person from whose custody it was produced.
But just tell us one thing, you have just seen the record, Mr. Borbi.
Lordship.
We didn't ask you this question particularly, we are waiting for the last. You are relying on this particular land document
Lordship.
stating that this other signature sometimes of 18th of May 1958,
Lordship.
and it's a 30 years old document. So under the Evidence Act, this needs to be accepted as evidence. But can there be an evidence of photostat copy or Xerox copy, a certified copy?
No, that was original copy as per information for this, the subsequently
Can you show
taken
us from
back.
here that it has been proved for original?
Here is the original, sometimes Lordship
Show us from
after.
this particular evidence before the trial court that this document was proved from the
Here
original.
I did not Lordship.
Please verify.
Here in this case, original is not here.
Mr. Borbujan, please
Lordship.
verify.
Here I find Lordship photocopy is there. But sometimes Lordship, after adducing the evidence, court return, the person asked for return.
Please
And
show us that this
all this-
document has been verified from the original.
Lordship,
Whether the photostat copy of a certified can be considered as a
there,
primary evidence or what kind of evidence in the Evidence Act.
It must come from.
The particular exhibit, because you have also annexed some copies, so see the exhibit. Show
Yeah,
us that it
here
is a-
photocopy retained in the retained Lordship.
See,
Here.
basically, all are aware of the fact that whenever the document is returned or something,
But
either it
here
should be
is-
compared with the original, right? So show us that it was compared with the original. You might have the certified copy, whether it was certified copy is the records available before you. That's the original record. Xerox or photostat copy of a certified copy. What is the evidence value?
Second, photostat certificate copy is a secondary evidence, Lordship.
So how it needs to be proved?
But here is the case, Lordship, here nothing, here mentioned photocopy retained in the file, Lordship.
See, basically,
That may have been returned to the party or application.
you can have large number of arguments, right?
Lordship.
But very specifically, when a document is exhibited, it is always written that verified from this particular document, right? Is there anything in that particular record? Yes, Mr. Sharma, where is that judgment? Posted copy of a certified copy cannot be considered as a piece of
Yes,
evidence.
I have.
Here, Lordship, my one submission, Lordship.
Yes, please.
Yes. Here, my lord, certainly they have produced the original, but here only photocopy retained in the office. Sometimes that is the practice, Lordship, the court below. After production of documents, Lordship, office retained the copy, court retained the copy after verifying, and the tribunal also nowhere mentioned that it is photostat copy produced. Right? So Lordship, even on this point, I may be allowed to take
Mr. Borbia,
chance
everything
on
is
that.
before you.
Yes. Tribunal also nowhere mentioned the
Not required.
court.
Not required.
No, it says I have produced the photocopy, that not taken into evidence. Lordship, normal practice after completion for parties that took back after verifying the documents. Lordship, I did not. Other documents are there. That documents only photostat copy retained.
Lordship, I will provide before that, Lordship, I want to submit regarding rebuttal evidence, Lordship.
I will come to that.
Yes, Lordship.
Come to that.
And regarding rebuttal document, I have 3 other decisions. Lordship, I may be allowed to place the same.
Okay, let Mr. Borbia finish it off, then Mr.
Lordship,
Sharma
then
will
my
be
friend
ready.
will submit.
Yes, which is the other judgments you are
Other
relying on?
judgment, Lordships, Motiur Rahman, 2021 GLT,
Which volume?
volume 1, 330.
Yes, then
Then paragraph 8, 9, 11, 12.
the next.
Next one is Lordships, Abdul Alik, 2013 1 GLT, 941. Abdul Khalik, bracket of Muhammad, MD, Barsas Union of India. Abdul 2013 1 GLT, 941.
Paragraphs,
Paragraph 9 and 10.
then
Then 2015 2 GLT, 617.
any relevant paragraphs?
Paragraph, yes, Lordship, paragraph 10 and 14.
These judgments relates to what?
This regarding evidence, Lordship, rebuttal of evidence,
Rebuttal of evidence.
rebuttal of evidence, documents not challenged. Motiur Rahman, Lordship, evidence not rebuted. That is.
Now, the cases which judgments you have cited relates to what?
This
Only rebuttal, but the proceeding relates to what?
documents, that may I read,
Arising out of
Lordship?
any suit or any
That-
appellate?
Lordship, I placed the documents that was not challenged, not
No.
rebuted.
Those judgments that you have
Lordship.
relied on, the backgrounds of the cases are some, it has been arose from the suit or any other.
Similar that, Lordships.
Okay, fine. Anything else you would like to submit?
And these are the decisions, Lordships, and
You are
one
relying on, right?
relying upon in the case.
So,
And first, very foundation of the case
So in
is,
the nutshell, your case is,
very
that
foundation is
there
wrong,
was
Lordship.
no proper
en-
inquiry,
No, yes, Lordship.
number one. Secondly, the documents that you have exhibited remain unrebutted.
Lordship.
So the unrebutted documents are not accepted while discussing the evidence. and Giving its opinion, the tribunal did not consider all those aspects.
Lordship, and my no consideration at all in the evidence and documents. No findings are there. No findings
Okay. Relating to your evidence,
relating to evidence, both documentary and oral. No findings at all.
anything else?
And Muslim Mandal case clearly shows that
No, that you have cited already.
Lordship cited. That is very much clear. That very foundation, Lordship, that inquiry is to be done, fair inquiry, fair investigation, that to make, and the while issuing notice, grounds to be grounds of reference to be forwarded along with the notice. That is also absent. So this has been failed to consider tribunal, Lordship,
Sure.
while considering the case. So, Lordship, my submission is a case of a good case for remanding the matter to examine, proper examination is required, and findings to be given by the tribunal on the basis of those documents. And since my fathers are not in dispute, mother's parents' name are not in dispute, their names appear very much. This is my humble submission.
Okay, Mr. Bose. Yes, Mr. Sharma.
Lordship. Regarding Lordship, death judgment, Lordship, 2010 4 SCC 491, Lordship. This LIC of India versus Rampal Singh.
2010
4 SCC 491, Lordship.
491.
2010 4 SCC 491. LIC of India versus Rampal Singh Bisel,
Yes.
Lordship. Where it has stated that under the law of evidence, it is necessary that contents of the documents are required to be proved either by primary or secondary evidence. Contents of the documents cannot be proved merely by filing in a court photocopy of a document, Lordship. Paragraph 31, Lordship.
Yes.
Apart from that, Lordship, regarding rebuttal, Lordship, I want to rely on a decision of this court, Lordship, Rampal, Lordship, State of Assam versus Ohabali, Lordship, 2641/2017, Lordship, paragraph 16,
WPC number
2641 of 2017, para 16, Lordship. On the other hand, this one, Rampal Singh Bisel.
Havali,
Yes, Lordship.
para 16.
Yes, Lordship. On the other hand,
Yes, please.
on the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mondal, reported in 2013 1 GLT 809. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. By mere filing of document without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged its burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance, Lordship. And same thing has been quoted in para 26 of Sarbananda Nanda Sonowal case, Lordship. And another case is, Lordship, 6344 of 2016 WPC. where, where it has stated that even if no objection is raised by the state to a document marked as exhibit by the
Yes, Mr.
proceeding.
Sharma, what is the citation?
Yes, Lordship, WBC 6344 of 2016.
63
44.
of 2016.
Yes, Rukia Begum versus Union of India.
Which para? It starts with
Lordship, page 4, Lordship, second para. Insofar contention of the learned counsel for the petitioner that since the state did not raise any objection.
para. It starts with
Insofar contention of the learned counsel for the petitioner that since the state did not raise any objection.
yes, kindly read.
Insofar contention of the learned counsel for the petitioner that since the state did not raise any objection as to filing of such certificate and marking of the same as exhibit, therefore the said certificate should be accepted as a valid piece of evidence as its face value. We are afraid we can accept such a sweeping contention on behalf of the petitioner. Under paragraph 3A3 of the Foreigners Tribunal Order 1964, a Foreigners Tribunal shall have the powers to regulate its own procedure for disposal of the reference expeditiously in a time-bound manner. Therefore, while conducting a proceeding, a Foreigners Tribunal has the power to regulate its own procedure. Paragraph 4 of the said order says that Foreigners Tribunal shall have the powers of a civil court while trying a suit under the Code of Civil Procedure 1908 in respect of summoning and enforcing in the attendance of any person and to examine him or her on oath, requiring the discovery and production of any document issuing commissions for the examination of any witness and directing the proceeding to appear before it in person. Therefore, applicability of the Code of Civil Procedure to a proceeding before the Foreigners Tribunal is confined to the four situations as enumerated in paragraph 4. A proceeding before the Foreigners Tribunal is summary in nature and having regard to the scheme of the Foreigners Tribunal Order 1964, it will be to perfect to hold that detailed rules and procedure laid down under Code of Civil Procedure and practiced in the civil court shall be applicable in letter and spirit in a proceeding before the Foreigners Tribunal. A Foreigners Tribunal is not bound by the strict rules and procedure provided under the Code of Civil Procedure. This is more so because in a proceeding before the Foreigners Tribunal, burden of proof is always on the proceedee, and he has to prove that he is not a foreigner but a citizen of India by adducing evidence which are admissible, proved and relevant having regard to the mandate of Section 9 of the Foreigners Act 1946. This burden which lies upon the proceeding never shifts. Therefore, the evidence that is tendered by the proceeding must be admissible in evidence, must be proved in accordance with law, and must have relevancy to the facts in issue. Just because objection to a document marked as exhibit by the proceeding is not taken by the state would not make that document admissible in evidence if it is otherwise inadmissible. Having said that, we may advert to the case in hand in view of what we have discussed above. We are of the firm view that since the petitioner had placed the reliance on Exhibit 1 certificate, burden was on the petitioner to prove the said certificate as well as the contents thereof, irrespective of whether objection was raised by the state or not. Lordship. This. And Lordship. And Lordship.
Yes.
Law has been settled regarding that lordship, a petitioner cannot go beyond pleading lordship. And regarding land document lordship, no pleadings are there in the written statement lordship. Not a single statement is there lordship that lordship they have a land in the particular place lordship. Not a single statement has been made lordship in the written statement lordship. So lordship, on later stage lordship, so lordship they cannot rely on such document lordship. Regarding written statement lordship, so many decisions has been given by this honorable court lordship, and law has already been settled that lordship.
So you want to say that with regard to the land document, there was nothing in the written statement?
Yes, lordship.
Let us see.
Yes, lordship.
Page 46, para 7. Page 46, para 7.
It is there at para 7.
Oh yes, lordship. Some it was skipped lordship from my.
So apparently these things were not discussed.
And lordship, page 57 of the writ petition, paragraph 8, regarding original document. Tribunal itself stated, compared the original. The proceeding second part is exhibited some documents which are compared with original and marked exhibit A to L, or the original produced.
Mr. Borgia, one thing,
Lordships.
your school certificate.
Yes.
Do you want to say that your school certificate, which is the link document with your father,
Lordship.
document is proved, whether the contents of the document has been proved?
Contents, lordships, regarding father and my name,
That's the contents of the document. Whether it
lordships,
is proved.
that evidence, my evidence is there, lordships, in the instant case.
See.
There is no rebuttal at all in my
Mr.
evidence,
Borgia, we are
lordship.
asking you again. You can establish it's good for you. Document has been proved,
Yes,
but the document and the contents of the document are two different things.
lordship,
This court has many other occasions also.
lordship,
There are reported, unreported judgments in this.
lordship.
You have already seen what the apex court has said. Now, that particular exhibit, which is the lead document for you to show that Hekamat Ali is your father. Right? Now, whether the contents of that particular certificate, school certificate has been proved or not.
If the document is a public document, that does not require to prove the person unless objected, unless contrary.
That particular
My-
document is not your daughter 30 years document.
I am not on that.
Now,
I am on public document, which are public, which are private. Public
Is it a
documents,
certified copy?
unless contrary is there.
is it a certified copy?
Which one?
That's
No, original certificate. Here's the photo. Original certificate I got is.
where
In the record, I also find lordship original certificate. And the court says that the original, all are original compared. In the tribunal itself says these are documents, original compared. I also sometimes find in the original there. And the tribunal itself, all are original compared with original. In the page 57, that school certificate exhibit G, and the tribunal also says compared with the original.
Okay, compared with original.
Lordship.
Now, whether the contents of the document is proved in
Lordship,
terms of
if
the
it is a
apex court
contrary,
judgment,
is a public document.
it's a
Lordship.
public document. There is no
Yes,
doubt about
public document just because I have placed the decision lordship earlier. In
it.
this case.
Contents, document is proved. We are asking you the contents of the document.
If any contrary is there, they objected, lordship, then they are required to prove, lordship. Otherwise not.
No,
No, they neither appear nor there is the evidence in the tribunal. So here
And-
they cannot.
and Lordship, on earlier occasion, Lordship, this honorable court has called for near
The
about 14
question is
school
the very
records, Lordship.
foundation in the
Call
case,
for-
lordship, when
And out of
in the
14, near
tribunal,
about
Lordship.
12 records has been found manipulated, Lordship.
They have to, if it was manipulation document, they have to raise the objection at the time of tendering my evidence and production of the documents, lordship. There is this CPC at the court timing again says the various
fine.
judgment, lordship.
Anything else?
Even till even the even disputing that the schools are the verify the school certificate. Court may for in the Zahir Habibullah's case, in a West Baker says, so court or tribunal to verify the facts, to find out the truth. It is a citizenship lordship question. Other all are my Indian.
Regarding school
If
certificate,
disputing,
Lordship,
all
my-
family members are foreigners. That one lordship that
regarding school certificate, my senior colleague has already submitted, Lordship, citing the Supreme Court decision regarding Virat Singh's case as well as our High Court's case in respect of Onima Das, Lordship. And Lordship, another case, I'm going to rely,
one
Lordship.
online submission.
Yes, Mr. Barwi.
Lordship,
Lordship.
my authority admitting I am the son of Hikmat. And all the documents contains my father's signature, not dispute at all. Authority very inquiry, my name and address written, where my name, father's signature written. I am the son of Sanchit. And the document, whole documents containing, I am the son. Public document.
WBC 2294 of 2016, Lordship, may kindly have a look at it. Page 22, para 22 to 24, Lordship.
WPC.
2294 of 2016. para 22 to para
Just a minute, coming here. School admission is the public document.
section 35 দাদা evidence check করব
This is Hamida Begum.
yes lord
Yes, what did you say?
para 22 23 and 24 lord.
Para 22.
yes lord
Read.
Exhibit 3 is a school living transfer certificate dated 28/8/2002 issued by the headmaster of Zere Bazar ME School, Karimganj, certifying that Hamida Begum was the daughter of late Muhammad Abdul Wahab and that she had left the school on 31/12/1989 after passing class 5 examination. As per admission register, her date of birth was 25/1978. This certificate was placed into service by the petitioner as a proof of age and as proof of her linkage with Abdul Wahab. This certificate can be of no assistance to the petitioner for more than one reason. Firstly, as per this certificate, petitioner had left the school on 31/12/1989. This certificate was issued 13 years thereafter on 28/9/2002. Thus, belated issuance of this certificate would necessarily raise legitimate questions about the bona fides of the said certificate. That apart, law on this point is well settled. School admission register is not a public record within the meaning of section 35 of the Indian Evidence Act. Therefore, it is necessary that contents of the school admission register would have to be proved. Lord. Also, Viratmak Singh's case has been relied in this case also. Lord, sir. Next para.
Contents of the documents to be proved.
Yes.
Documents, Lordship, public documents, section 74. The husband reflect 35. 35 is the oral evidence. I do not know, but evidence act appears public documents, section 74. And regarding that, my contents of events, I already placed before your Lordship that paragraph specifically states contents is required or not. That to the 9/12 I placed before Lordship. Paragraph 22 again I am reading. It has been held in Dosarando Singh versus Jalan Singh that an objection is to the admissibility and mode of proof of a document must be taken at the trial before it is received. in evidence and marked as an exhibit. Even otherwise, such a document falls within the ambit of Section 74 Evidence Act and is admissible per se without formal proof. And regarding contents of documents, Lordship, one more judgment regarding certified copies, what the Supreme Court says, that may kindly be taken note, Lordship. That is, since my learned friend objecting that contents required. 2012 1 SCC.
Yes.
425. Jaswant Singh versus Gurudev Singh and others.
What do you want to say from that?
In the paragraph 13, Lordships, paragraph 13 after 6-7 lines, Lordships. Hence, documents that now the other question which remains to be decided is whether compromise exhibit D3 is admissible in evidence or not. The compromise dated so and so has become the basis of the decree dated so and so passed
Which
by the
para, which para?
paragraph 13, Lordships. Paragraph 1-3.
Yes, please.
Yes. Lordship got it. Now the other question which remains to be decided is whether the compromise exhibit D3 is admissible in evidence or not. The compromise dated 27/11/1972 has become the basis of the decree dated 8/12/1972 passed by the sub-judge Hoshiarpur. The perusal of exhibit D4, that is judgment and decree, were passed as per the terms and conditions of the compromise placed on file. As rightly observed by the courts below, the compromise has merged into a decree and has become part and parcel of it. To put it clear, the compromise had become a part of the decree which was passed by the court of sub-judge first class Hoshiarpur. Hence, it is a public document in terms of Section 74 of the Evidence Act 1872. And certified copy of the public document prepared under Section 76 of the Act is admissible in evidence under Section 77 of the said Act. A certified copy of a public document is admissible in evidence without being proved by calling witness, inasmuch as the decree was passed and drafted in the light of the compromise entered into between the parties, which the plaintiff and the defendant. The certified copy of such document which was produced before the court, there is presumption as to the genuineness of such certified copy under Section 78 of the. So even certified copy court says there's not require calling
Section
for.
76 is very clear of the evidence.
76 is regarding certified copy. Even if it is a fall under public document, not required to calling of the witness, Lordships. That is court says, Lordships. So my school certificate is a public document. Not required to calling for witness to prove, unless it is contrary to. These are my humble submission, Lordships.
Both of you give us a short written
Yes.
argument by day after tomorrow. List.
Yeah, please, Lordship. Lordship, I beg to mention item number 4, my lord. We taken up on some other day, my lord. In the second half, I have some personal difficulty also.
It's at 2 at port number 21 hearing also. Can it be some other day also?
Item 9,
9 for hearing also.
9 or 10.
9 also.
9 already adjourned.
9 to
And already adjourned.
9. More 7, sorry, I'm sorry. 7.
Okay.
Always.
Madam Chakraborty yesterday telephoned me. He has some difficulty today, probably. I've seen his junior. It can be on Friday, madam. Long pending issue, madam. Regarding memorandum of charges, because allowed by the learned tribunal on the ground of delay. And also in this charge memo also, there is no financial loss today. On the
So,
ground of delay.
Mr. P. Chakraborty has informed you.
Yes, ma'am.
Whether he informed you which date to be fixed.
Yes, Friday, any date he has come to, Friday, my lord.
Thursday,
Thursday, probably he has gone somewhere, Kohima, he has gone to Kohima. Probably Friday,
on 12th.
12,
12th he'll be in Kohima.
probably Kohima.
Then we'll have it on 17th.
17th, I will not be there, my lord. Yeah, November.
The last one.
No. 12, can be fixed on 12 probably.
When he will return from Kohima.
Yesterday, telephone he has gone to Kohima. Today, probably his case is there. Friday, if possible, Monday,
Same thing, Friday and Monday.
and Thursday, lordship can fix the matter.
Thursday, 18th.
18. No, no. I wrote 12. No, no. From Tuesday, I will be out of station. From
Okay,
7.
On 12th.
Okay.
No time being, brother.
Lordship, in this matter, we have received instruction. So Lordship may post it after vacation. We will, in the meantime, we will file a repeat Lordship.
You have not yet filed.
No, no, not correct. We have received the instruction, Lordship. Lordship directed the respondents to file a repeat.
What's your good name?
One.
You are referring for whom?
K. Kolita for KK Paraswar, CGC, for respondent number 1.
Heard Mr. Rai Chaudhary, IU. For the petition.
আসলে গভর্নমেন্ট আমার মেন রোল তো গভর্নমেন্ট স্টেটমেন্ট দিচ্ছে না মেন রেডি আছে মেন রোল তো
When he was acquitted,
Lordship, I have annexed the order, Lordship, dated Lordship, 4/8/23, Lordship, page 25, Lordship. Date of judgment 4/8/23, Lordship. The 11th page, Lordship, will find page 40, Lordship. Page 40 is the order.
when he was released. Or still in custody.
Lordship, I am still in custody, Lordship.
The reason why?
Man is the statement. Lordship, as
Give it to us.
per the instruction,
Given us an instruction.
Lordship,
Give us a.
he is related to this trafficking of drugs, Lordship. And everything was communicated within stipulated period of time, Lordship.
not only this case, other cases.
There were other cases also. In those cases, after his release, again he resorted to these kind of activities, Lordship, without having any remorse.
In other case, Lordship, he is on bail. Lordship. That is all below.
Why don't you prepare a chart? Because you are involved in certain
Lordship,
NDBIS case, right?
Lordship, two cases, Lordship.
Which are the cases you have been granted bail and in which cases you have been acquitted?
Lordship.
Give us a chart. Has it been
Lordship.
informed?
Kindly, Lordship, bear with page 44, Lordship.
Page 44.
496 is the present
Ah.
case. It is the bail question.
Yes.
There's two cases, Lordship.
496 and 213.
496 and 213, Lordship.
Now, in which case you have been granted bail?
Lordship, two, Lordship.
In both the matters.
213, Lordship. 213, Lordship.
In 213, you have been
On bail, Lordship.
released on bail.
Lordship. And 496, I'm on acquittal, Lordship.
496 acquitted.
Lordship, acquittal, Lordship.
213 and bail since when? Where is that bail order?
$56, no? 56.
And it's 56.
56, Lordship, page 56.
56, Lordship. Special case number 25 of 21. Lordship. Registered under section, Lordship, 21B, Lordship.
$25.1 for commercial quantity. Heroin.
granted bail on 1/10/2021, Lordship. And the detention order was passed on, Lordship, 18/4/23, Lordship.
Only reading or সময় ললে বলে একটা draft affidavit খন ইয়াতে আছে টাইম দিলে মানে petitioner পিছন নালাগে তেওঁ আহিয়ে আছে already Friday
At the time of passing the detention order, Lordship, he was on bail, Lordship.
এনেকে
Monday. 16.
আমার এফিডেভিটটা একটু রেডি হয়েছে
Draft copy here. Monday. No, by Friday we'll file. 16 will be Monday. 13th I file for you. By 13th we'll file. Today is 10th. Next week. Went to detention matter. Equitable is different, detention is different. Peter
Lordship, may pages page number 48, Lordship.
Just a minute.
Our orders detaining certain persons. Getting I not advisory board. 3 to 3 to perhaps. With a view to preventing him from engaging in illicit, preventing him. Equitable health and even correct. Yeah. Black. Prevention of illicit, no? Illicit traffic. Illicit.
Prevention of illicit trafficking, drug and psychotropic substances, and
Illicit drugs. Okay, 88.
88.
Corruption.
So, and psychotropic.
NDPS খন লগতে এইখন জম্মু কাশ্মীৰৰ এই ওপৰখন নেকি এইখন?
Section 3. Line talks about advisory boards.
বৰ্ডতো হেৰি কৰিছে।
For its execution of detention order.
আমাৰ হেৰি satisfaction আমাৰ satisfaction ওপৰত ডিপেণ্ড কৰে আৰু with a view to restrain him. এই যে কথা কৈছে this is wrong. This is wrong. Secretary is the authority. A02, when any order of detention is made by state government or by an officer empowered by state government. So secretary is the empowered officer here. ৰাতিপুৱাৰ পৰা এটাও হোৱা নাই, এতিয়া গোটেইকেইটাই একেলগে মাতে। ৰাতিপুৱা কিয় মাছ আছে ক'ত বিচাৰিছে জানো পাওঁ। এখন রেডি আছে মোৰ দুদিন টাইম লাগে মই থাৰ্সডে বা ফ্ৰাইডে ভিতৰত ফাইল কৰিম ৰেডি আছে coordinator executive something that is it is a detector প্ৰতিখন লাগে যেটা কাইলে দিলে হ'ব গোটেই সোসাইটিখনতে ইম্পেক্ট কৰে youth pick কৰাটোৱে into living under youth pick কৰাটোৱে coming under the influence of drugs exactly
He has not filed any representation. I have filed. But there was also
rejected
when did you file?
That 27/5/2023. That annexure is what you will find at page 15.
representative confirm হেৰি কৰিছে নে ৰিজেক্ট কৰিছে নে ৰিজেক্ট কৰিছে
In the representation, he clearly said that he was not supplied with the police reports on the basis of which the impugned order is passed, and there is no likelihood of releasing him on bail. Those aspects are placed before the advisory board.
yes
Which page your representation?
Page 50. In this case, although lordship they passed the order on 18/4/2023, they served him the copy subsequently, lordship, on 8/5/2023.
yes maybe
Not immediately.
Mr. Nath,
Malad our
file your affidavit. We will
our
have it on
affidavit-
Tuesday next.
our affidavit is ready Malad will file lodge
But if that is the these materials, but we do not know about the other status.
Malad
You have to clarify when did you first inform the petitioner?
yes Malad
Because what we have seen here, the
Lordship.
date that he has mentioned, Mr. Azad has mentioned, is the date on which you have informed.
lodge
File your affidavit.
yes Malad will file Malad otherwise Malad all the requirements of law it doesn't been complied with Malad I'll advise your lordship in fact the advisory board it was placed before the advisory
That we have
board
seen.
board has already given their views Malad. And the materials have already been supplied I'll place Malad.
You file it by this Friday.
I'll
Have
by
it on
Friday.
Tuesday next.
Malad.
The state respondent shall file its affidavit. Heard Mr. Azad, counsel appearing for the petitioner. You are Mr. Khalid, Mr. Parasan, Lana CJC, for the response number 1. Also heard Mr. D. Nath, Senior Government Advocate Assam. Respondent numbers 227, 228. Here is the written instruction of the respondents in the Home Department of the state placed before the court by Mr. Dinat. The affidavit on the basis of the said written instructions shall be filed by the respondents in the Home Department of the state on or before
By 10 of 13.
16th of October by serving a copy of the same on the council for the petitioner. List on 17th. Along with the affidavit.
Yes, yes.
That is affidavit.
Lordship. बाकी तुम्हें समा रखो.
Yes, Madam Aditya.
This is contested with my lord, petitioner's father's name recorded in the voter in 1960.
Where is the link document? Let us see the first straight with the link document.
Linkage.
Where is the link document?
All the link documents are my lord, this LCR my lord, and I have one transfer certificate is there.
You relied upon which document?
My lord, in this petition, I have not annexed any linkage my lord,
You have,
which is father's my lord. Page 13 is this petitioner's father's name my lord.
so how do you establish your, wanted to establish your case before the
My
tribunal?
lord, I have transfer certificate also is. That is
Transfer certificate of what?
my lord, Jamuna Mukh ME Madrasa student up to +5 my lord.
It was, you left the school which year? You left at madrasa which year?
My lord, 31st 12/1985 my lord.
You have left at madrasa in the year 1985,
My lord,
December 1985, right? Now, when did you procure this certificate? When it was issued to you?
date is not.
It was immediately or after some time?
110/15 my lord. 110/15 my lord, sir.
1/12/15,
110/15 my lord.
1/10/15 after 10 years. 85,
My lord.
2015, there is another
On that
15
time,
years.
my lord, not required my lord.
Hmm?
On that time, it's not required my lord. And Gabuda certificate from my lord here my lord.
Have you adduced any evidence of these authorities? The person who issued this school certificate, transfer certificate?
No, but it was not proven.
Not proof my lord.
It was not true. Now, what will be the evidentiary value of this particular certificate? Transfer certificate that you
Gabuda
have,
certificate also there.
this transfer certificate of the madrasa concerned, right?
My lord.
What will be the evidentiary value? It was issued on 1st of October 2015, stating that you lived at madrasa in December 1985. 85 to 2000, another 15 years, and 110/2015, 14 years, 10 months.
My lord, headmaster not to prove my lord, if
Now, what will be the evidentiary value of this transfer certificate? To tell us. This is your link document, right? So what will be the evidentiary value of this transfer certificate? If you can establish it that by exhibiting the original transfer certificate of 1/10/2015 is enough to indicate, to prove your linkage with your father, it's sufficient. But before that, you have to tell us that the certificate which you have obtained or procured after more than 24 years.
Admission register may be called for my lord. Admission register may be called.
That doesn't help you. Admission register will calling why? We are not supposed to here to look at the evidence. Whatever the material is available before the tribunal, on that basis you have to tell us.
Tribunal not to examine my lord. Tribunal not to examine my lord the register, admission register.
Why the tribunal rejected your claim? You are agreeing against the order of the tribunal, you can understand, but what is the reason why the tribunal did not consider these documents?
On the basis of this, my lord, the age discrepancies, my lord, that is page 24, my lord.
where you have stated in your written statement that you have read up to class 5 Jamuna Mukhemi Madrasa.
This statement is not there, my lord.
Then whether that particular document can be accepted as a linked document. You are silent with regard to your school certificate or your about any education. Right? Now let us assume that you are silent with regard to that. In your written statement, you did not state
My lord,
that your name is Akhil Ali Borhuia or that your father was Moinuddin Borhuia. You have said that Akhil Ali, in some of the cases written as Akhil Ali. And similarly, Moinuddin as Moinuddin. There is nothing about Borhuia.
my lord, petitioner's case may be remanded back to the
For
tribunal.
what?
But he has produced all the documents, my lord, whatever.
That you could have done it, file an appropriate application under the order of 64 before the tribunal itself. We have preferred this state petition. Where is the illegality?
My lord, one chance may be given, my lord.
The Gaura did not adduce any evidence. Right?
Yes, my lord. Gabura
So-
has been produced.
See, to help you, you have to give us some handle. Where is that? Without those things, how can we consider the fact that we should remand it back?
My lord, petitioner has all the documents, my lord. Gabura certificate is also there, my
No,
lord.
it have already, Gaura has given.
My lord.
Gaura has already given a written certificate, handwritten certificate, doesn't matter. But the Gaura hasn't produced any evidence. So,
My lord, petitioner's case may be remanded back to the tribunal and.
see, that's the reason we are asking you. First of all, we are sitting here to execute the power under Article 226, not under any other writs, but especially under such order. You know the reasons, in which circumstances the such order can be issued. Now, for that purpose, for remanding the matter, show us any material. This is the reason it should be remanded back to the tribunal for reconsideration. For what? We understand that the citizenship is a valuable right. We all. Anyone can face that trouble, right? We can understand that. But thing is, this for that purpose, you need to have something. Let us assume you are saying that your name figured in the voter list of 1997 along with your parents. But why in the year 1997? Why not prior to that? In the year 1997, you are 25 years old. Why only 1997? Why not prior to that? There was elections, there were voter lists prior to 1997.
First time his name is recorded 1997. my lord.
Why? Why?
Thereafter, my lord, continue.
Who is Sophia Khatun? Who is Sophia Khatun?
His mother's, my lord.
Where you have stated? In your written statement. Have you stated so?
No, my lord.
Now, if you read the judgment of the Sarvananda Sonowal, paragraph 26, you are bound to disclose the name of your father and mother, your place of birth, the date of birth. Have you disclosed in your written statement? That is why I am asking you, give us any handle to help you. Where is that handle? Simply asking for a remanding on the matter will not help you, man.
My lord, the petitioner,
Who was Anbul Khatun? Who was Anbul Khatun?
That is also stepmother, my lord, petitioner's stepmother, my lord.
Where you have stated that Anbul Khatun is your stepmother.
My lord,
Is there anything in your
no, my
written statement
written statement not properly filed, my lord.
that you cannot at this stage? It is neither there in your evidence and affidavit in evidence.
No.
After 1997, why 2015, 2005? In between, what happened?
All the documents is there, my lord, but not annexed, my lord.
At least Moinuddin should have the voter list after 1970. If not, Akil Ali. Why after 1970 it is 1997?
Petitioner's father's, my lord, Moinuddin, his name recorded in the voter list 1960 also, my lord. And there are
We understand. What happened after 1970? If you are saying that
my lord.
you are the son of Moinuddin, then the voter list of after 1970 should have been continuously there. So this other way from 1970, Moinuddin was missing.
Died, my lord. Petitioner's father's.
Hmm?
Petitioner's father's, my lord, died.
Where? You have annexed voter list of 1997 after 1970.
Nothing mentioned, my lord.
After 27 years. But many voter lists came in between. Anything else you'd like to submit?
My lord, end of justice, my lord, for this petitioner's case may be considered, my lord.
For what?
My lord, he's properly filed his written statement and other documents, sir.
Written statement was filed on 18th of September 2015.
My lord,
So
but all the documents is not mentioned, my lord.
what are the other documents you left out?
My lord,
What are the
voter
other
list and,
documents? Huh?
all the voter list, my lord, not annexed here, my lord.
That is up to the procedure to decide, madam.
In this judgment, my lord, page 25, only discrepancy of this, my lord, age of this petitioner's father's, my lord.
Age of the discrepancy of the age of whom?
Petitioner's father's, my lord.
Petitioner's father. Only that was the ground only where it was rejected.
Not, my lord, some other reasons also.
So then that's only one part. To interfere with this judgment, you give us a handle that we are asking for you. Okay. Mr. Payang.
Well, first of all, my lord, I'd like to point out one thing, my lord. From the, though WS is not annexed, my lord, from the evidence, from the judgment opinion at page 24, my lord. Page 24 is the basis, on the basis of which, my lord, the opinion is passed. The page 24, my lord, your lordship may kindly see, exhibit 3 is the certified copy of voter list of 1997 of Jamunamuk LSC. The projected father's name is Opis, appearing at so and so. As per exhibit 12, if the father's age of OP was 51 years in 1966, then in 97, after 27 years, his vote has ought to have been 82 years and not 70 years as reflected in exhibit 3. Such difference of age of 12 years of the father of the OP has not been explained anywhere in the evidence of DW1. And as such, the father of OP, namely Moinuddin, whose name appeared in exhibit 3 is not the same Moinuddin whose name appeared in the exhibit 1 and 2. Therefore, exhibit 1 and 2. Therefore, the father of OP as per exhibit 1 and 2 is the projected father and not the actual father who gave birth to him. Next part, that is most important. Moreover, as per the own admission of OP DW1, his mother name is Miss Musammad Sophia Khatun, whose name appearing at serial number so and so in exhibit 3 is 60 years. Now,
You are reading in which page?
Page 24. Page 24 of the writ petition. Judgment, in the opinion part, madam.
Moreover.
Yes, moreover, this is more important, most important, madam. Moreover, as per own admission of the OPDW1, his mother name is Musammad Safia Khatun. Because if Musaffat Safia Khatun is his mother, this thing has not been explained anywhere. And 66, one Anbul Khatun is there, my lord, along with one Moinuddin in page 19, my lord. So, and interestingly, the writ petition page 4, my lord. Even in the writ petition also, he has not said that. Writ petition, he has said. Writ petition para 2, my lord. The petitioner father late Moinuddin so and so was permanent resident of so and so. Now, the name of the mother of the petitioner is Anbul Khatun. So, Anbul Khatun, my lord, why? The logic behind is that, my lord, in 1997, put a list, one Moinuddin was well with one this mother Safia Khatun. But in writ petition, he has said that his mother name is Anbul Khatun. Here in the matter page 24, he himself said that his mother name is Safia Khatun. And from the entire writ petition, my lord, I have gone through the entire writ petition. There is no statement apart more about only this is the statement with regard to her parents and whatever, my lord. There is nothing. And there is no ground of silence of this writ petition, this opinion. There is no, my lord, ground as to why this opinion should have been set aside. They have not silenced that finding is wrong. He has picked up the 1966 voter list to link somehow to a person named Moinuddin. All others are different because they are the wife of Moinuddin is different. Here in 1990s, Moinuddin is different. So in evidence, he said, my lord, his mother name is Safia Khatun, whose name is appearing in 1997 voter list. But in fact, my lord, in WS and in my lord, writ petition, he has not said that his mother name is Safia. This is all contradiction of himself, my lord. Taking falsehood. Apart from the age discrepancies and others, my lord, this issue, because he himself contradicted about his mother's. Then exhibit 7, my lord, that is the certificate issued by village headman, that is not proof. And the school exhibit 8, school certificate, that is not proof. And if this exhibit 7 and 8 goes, and the, my lord, the 97 voter list, which seems to be doubtful, because the not even doubtful contradicts it himself by saying different name, my lord. So there is nothing more. And in 1997, if we compare the 97 voter list along with 2000, my lord, to 1966 voter list, in between, obviously there is no voter list, no documents, my lord, for 27 years. But even though we accept that there is a, my lord, document in 1966 and 1997, my lord, the document itself contradicts each other. Because in 1966, the mother is Anbul Khatun, and 97, it is Safia Khatun. And in one place, he said his mother name is Anbula Khatun, and one place he said his name is Safia Khatun. So it makes itself makes clear doubt. And my submission is that this is findings of the tribunal. There is no error apparent on the findings in the tribunal matter. And the facts, as your lordship has already read out, the under 226 certiorari jurisdiction, the court has to see the whether error apparent is there. The decision, the facts which is already decided, facts which is found by the which is by the tribunal may not be interfered by this honorable court. I want to just read one line, my lord. It's regarding certiorari jurisdiction. Apart from other, apart from other aspect, my lord, if your lordship, only one line I want to rely. The Muslim Mandal in para 112, my lord. Only one line I want to read out. Because humanity.
Madam, please take your seat.
Your lordship may kindly say that. Only one line, para 112, my lord, it is there. The certiorari jurisdiction of the writ court being supervisory and not appellate jurisdiction. The court cannot review the finding of facts reached by the inferior court or the tribunal. So this is the tribunal has, my lord, tribunal's findings on facts may not be interfered by this honorable. If there is error apparent, that's a different issue. If beyond jurisdiction the tribunal has done, that's also a different issue. But the findings, it may go this way, it may go that way. We cannot decide, my lord, we cannot interfere on that. So same thing, my lord, in different, this honorable court in numbers of case, my lord, it is the proposition has been taken. Finding based on appreciation of evidence is a finding of fact. Ordinarily, the writ court would not interfere with such findings of the fact because of the jurisdiction exercised in supervisory, not appellate. This is in another case, matter, this honorable court. Let's see. Look, what my submission is that the facts, findings of the facts by the tribunal may not be interfered. The findings is clear, madam. There is a age discrepancies the my lord, mother names are different in different documents, and the my lord, the birth certificate and the my lord, the government certificate has not been proved. So finding is that he could not prove his citizenship. I'm not pointing out the discrepancies because it is admitted position, my lord, discrepancies are there. The documents are not proved. There is no documents in between 1966 to 2007. How his name is suddenly appearing in 1997. And there is no explanation in WS in evidence with regard to all these facts. So these are circumstances and findings, my lord, findings. Further, they have not specifically challenged any findings before this honorable court in this writ petition. Even, my lord, they have not mentioned with regard, as your lordship has seen, neither in the WS nor in the evidence, even not in the writ petition, they have mentioned about the school certificates. The school certificate is not mentioned in the writ petition. Not explained the same things, my lord, which the learned tribunal has said, these things are not explained in the evidence in WS. These things are not explained in the writ petition also.
Anything you'd like to add?
My lord. Lastly, my lord, my humble prayer before your lordship, my lord. End of justice, my lord. Petitioner's case may be considered, my lord. He is properly, all the documents is, my lord, produced before this honorable.
Show us that we can pass that order. On what basis? Would have passed that order.
Yes, my
That
lord.
is the reason we are asking you, give us a handle to pass that order.
My lord, petitioners have some of documents, my lord, that are not disclosed in this tribunal, my lord.
For that, always you can do it
There is
before
a
the,
discrepancy also.
you could have filed application under order 1964 before the tribunal. Why? What is the judgment, Mr. Pine? That the Superintendent of Police Board is has the jurisdiction to, or the authority to refer the matter to the tribunal. This was earlier considered on the basis of the notification of the
Yes, ma'am.
two notifications of the
There are
central
two
government, right?
notifications. There are two notifications, my lord.
It was considered in by the coordinate bench of this court, right?
Yes, madam. My lord, your lordship may find it is, this is WPC 4989 of 2016. This issue, exactly this issues were.
No, those two notifications of the central government
Yes, madam.
that was considered. You are aware, right?
Yes, madam. This is another one case, my lord. Your lordship may kindly say, I'm looking to that another judgment, my lord.
There are, I remember.
Four nine eight nine of 2016, there are this was one of the case where this issue came up, my lord, the same issue. Three issues were there, whether the police has power to make inquiry, investigation and examination into the nationality of any person, whether any procedure is laid down under the statute conferring and regulating the power of the police to make inquiry, investigating the examination.
4989.
Yes, 4989 of 2016.
2016.
Yes, ma'am.
That is something different.
There are a number of cases, madam.
4989 2016, which order?
This is 83 2018, madam. Probably these writ petitions were not disposed of, madam.
No.
Yes, these writ petitions were not disposed of, but the issue came up, the issue was decided.
It's not before us. 83 2018.
Yes, 83 2018. This writ petition was also there, probably. This writ petition, no? I don't know.
There are a series of writ petition. 1, 2,
Yes.
3, 4, 5, 6, 7, 8,
6,
9 writ
8, 3,
petitions.
yes, 6, 8, 3, 7. Probably this writ petition was also there, but it is not. The issue, same issue was there in madam.
6, 8, 3, 7. I don't think so.
This is not there, madam.
This is not there.
But the issues were madam similar to this one. There the issue was decided, the writ petition was left pending for madam, for disposal on merit, madam.
Boro, he order to order dated 8/3 2018. WPC number 4989 2016 and other connected cases. Idris Ali, Muhammad Idris Ali, MD Idris Ali versus Indian 6 others.
So this issue was there, madam. This issue was settled, and writ petitions were left for my lord disposal on merit. This case was not there. Huh?
No, I remember it. I have read one particular order of the court where
There are 7, my lord. It is mentioned.
both the notifications
Yes.
were discussed.
Another inquiry.
Because two notifications of the Election Commission of India were there.
That is not a Government of India, Ministry
Government
of
of
Home,
India.
Home Department.
Yes, Home Department. True, I have known.
Yes. That is on 17 to 1976 first notification.
Whereby the second notification empowering the Superintendent of
Yes.
Police Boarder. Where is the other notification?
Another is my lord. First notification is 19 for 1958.
I think there is another order.
Yes, another order is there, my lord. I'll just produce it. Let me-
Where both the notifications of the central government were
Yes, yes,
discussed.
there is another, and even in fact, this was also there, my lord. Here, this issue was, my lord.
No, initial issue was that the SP border has no such power to forward the matter to the tribunal.
Yes. My lord, 76 your lordship will find para 7 itself, it is clearly said. Para 7 of this statement. As Sikar learned that Solicitor General produced before the notification dated 17/02/1976 of the Government of India Ministry of Home Affairs, entrusting Superintendent of Police of the Deputy Commissioner and Deputy Commissioner in charge of police under the Government of Assam, the function of central government in making orders of the necessarily specified under clause so and so of the Foreigners Act with their respective jurisdiction, subject to the condition that mentioned therein, including the condition of conditions that the functions so entrusted shall be exercised in respect of the national of Bangladesh. So this notification was referred.
মাইলক বাৰে বাৰে গুচি গৈ থাকে লটিকা শৰ্মা এইটো কিবা চেভ কৰি থব পাৰি না
I have the copy.
No. Yeah.
Let me see another judgment. Here it is the
Just 17 and 17.1 of that judgment that you just relied on, that order of 8th of March.
Seventeen one, my lord.
17 and 17.1.
Yes, my lord. These two notifications. One is 1958, one is 76.
No, this is the order where the Superintendent of Police has been specified that come to para 22. But there is a particular order of the court that it is the Superintendent of Police border who can make such reference.
Yes, my lord, probably.
They also discuss about the post of Superintendent of Police of border. Why border?
Oh, that's differentiation of SP border and SP. Yes, there is probably one judgment.
Which is the other one you are talking about?
Another judgment here, my lord. Your lordship may kindly see.
Because the petitioner has raised that issue in the writ petition.
Yes. No, my lord, this issue, in these writ petitions, my lord, these issues were there.
It's there at para.
I have to verify that, my lord. Probably. There is in judgment.
Because if you read para 5 and 7,
Yes.
you'll get it.
Yes. But your lordship may This is my lord, WPC 7932 of 2015.
Which order?
7932 of 2015, order dated 14/3/2018, my lord.
Vishwajita, please take your seat.
Para 25, my lord. Contention of
Coming. Saira Khatun.
yes, ma'am. Dear super.
Which para?
Para 25, ma'am. Regarding second contention of the learned counsel for the petitioner, the reference was made by Superintendent of Police Tuguri and not by the Superintendent of Police Border Tuguri, and therefore reference made was without jurisdiction. We have informed at the bar that Superintendent of Police of District is designated as Superintendent of Police Border while discharging function in connection with the border wings of the Assam Police, which has been specifically constituted to deal with task of detection of foreigners in the state of Assam. Therefore, Superintendent of Police and Superintendent of Police Border is the same officer, though they may perform different functions at different times. It is an internal arrangement made by the Assam Police. Ideally, it would have been better if the Superintendent of Police Tuguri had suffixed the word border along with the designation, but to our mind, non-mentioning of this same would not be a fatal. The objection raised on behalf of the petitioner is more from then of substance. This was with regard to the manner border.
Not putting border in the SP, right?
Yes, ma'am.
No, I remembered one judgment, one order where those notifications of the Assam Police as well as the central government, both the notifications were incorporated and part of it.
I have to verify, my lord.
There is, because we have gone through those two notifications.
Yes. Those not. Yes, my lord, this issue probably because in the earlier, yes, in the judgment, my lord, in the jurisdiction, this in the earlier judgment, my lord, for it 4989. The authority of the police. The no authority has been given to the state police to make an inquiry. And it says just minute para 9 minute, it was in his reply submission, Mr. Barbuya, Learned Counsel asserts that he has not questioned the exercise of existence of foreigners tribunals or the power of the police to make reference. What he has questioned is the absence of procedure regarding the inquiry proceeding, the reference because which is a large number of bona fide citizens of the country. That was the issue there, my lord, here also. The para 5, my lord, contention of para 5 of the writ petition, that was seen in para 12 of this judgment, my lord. Under 12.1, in para 12.1, the same issue is still. In exercise of a power conferred by Section 3 of the Foreigners Act 1946, the central government made the Foreigners Order 1948. According to clause 3 thereof, no foreigner can enter into India otherwise than at such port or other place of entry on the border of India as a registration officer having jurisdiction may permit or without the leave of the civil authority having jurisdiction at such port or place. Then para 13 minute. Article 258 of the Constitution deals with power of union to confer power, etc. to the state in certain cases. Clause 1 of Article 258 starts with a non-obstantive clause. It says, notwithstanding anything in the Constitution, President may, with the consent of the government of a state, entrust either conditionally or unconditionally to the government or to its officers functions in relation to any matter to which the executive power of the Union extends. Clause 3 provides for making of payment by the government of India to the state concerned, such sum as may be agreed upon or in default of agreement through arbitration in respect of any extra cost or administration incurred by the state in connection with the exercise of the powers and duties of the government of India conferred or imposed upon a state government. Now, para 14 days, Ministry of Home Affairs, Government of India had issued notification dated 19/4/1958, which was extended in the case of Anwar Supra, which is extracted in the case of Anwar. The said notification issued by the Government of India, government in exercise of the power conferred by clause 1 of the Article 258 of the Constitution, whereby President, with consent of the state government concerned, entrusted to the government of each and states mentioning therein, including the state of Assam, the functions of the central government in making orders of nature specified in section 3(1)(c), so and so, Foreigners Act 1946, and under the Foreigners Order 1948. While extracting the said notification, Supreme Court held that the notification was a complete answer to the objection raised that it was the central government alone which could make a lawful deportation order, section 3(2)(c) of the Foreigners Act 1956. In the year 1964, the central government, in exercise of the powers conferred by section 3 of the Foreigners Act 1946, had made the Foreigners Tribunal Order 1964. Paragraph 2 thereof deals with constitution of the tribunals. Paragraph 2, this is with regard to the tribunals. So here also issue was the same one. As your lordship has seen 17(1) and 18, my lord. 17(1) again, the central government notification of 1966 after 1958. Thus we have two central government notification, one dated 19/4/1958 and the other dated 17/2/1976, entrusting the government of Assam, Superintendent of Police and Deputy Commissioner in charge of police to make orders of nature specified in section so and so, and after obtaining opinion from the Foreigners Tribunal by making reference under paragraph 2 of the Foreigners Order 1964. Thus, there can be no dispute as to the legal foundation on the basis for establishing and functioning of Foreigners Tribunal in the state of Assam. As a matter of fact, Supreme Court in Sarvananda Sunwal, this is.
No, there is, I was looking for this.
Especially the power of the Superintendent of Police.
Some forms were there. In the form, it was very specifically mentioned about those two notifications. Do you remember?
Those forms, my lord, in fact, those, the issue, my lord, what, as per I remember, my lord, the forms were in the IMDT cases, my lord.
Huh.
Not,
there the
yes.
notifications are mentioned.
Yes.
In the IMDT cases.
IMDT cases.
Not there it has been shifted here. Those two
Yes.
notifications are mentioned in the IMDT cases.
Yes, ma'am. Because otherwise the prompts are not available.
Exactly. But in that particular judgment, I still remember that the forms were incorporated.
Yes. Let me
There
go
are
through. Let
two
me go
forms
through.
are there.
Let me go through the judgment, ma'am. But with regard to my lord, that is with regard to the particularly with regard to the inquiry by the police. I will go through, my lord. Let me check it out.
Because in those forms in the IMDT Act, I had a book, I don't know where I'm reading it now. Those notifications, then there's a book by some lawyer. The important judgments in the citizenship faculty foreigner.
This book, my lord.
Probably. Find out there has to be those two notifications. Cover page has changed probably. Because that's why I was looking for the Gogoi's book. In the Gogoi's book, it is not there.
Oh,
Yeah.
Notifications are there, my lord. Notifications, yes, I have also remembered in some cases notification is quoted out. Notification is quoted out.
That's
It's,
what,
it's there, my lord.
Because-
I'll find it out.
in the IMDT cases, those forms, the
Yes,
notifications are there.
yes. No, in some judgment, notification is quoted out, my lord. I have seen. I forgot that judgment. I'll find it out.
Probably it was Justice Bhuya's judgment only, whether Form 1, Form 2,
Yes,
those forms, because it's not available under this Foreigners Act, available only under the IMDT Act. That's what it was discussed.
I also remember, your lordship, I can produce those two notifications.
Okay.
It is there somewhere. I'm state out probably.
Which is the judgment, thereby those matters pending before the tribunal under the IMDT Act to be re-registered under the Foreigners Act. There is, the 4 categories are there, I think so.
That is, why not in Sabananda Sunar one itself, it is there.
No.
But thereafter, this honorable court in full bench decision.
I
It is a
think-
full
I
bench
think-
decision. Yes.
What is that full bench? Because there are 4 types of cases left out. That it is another full bench judgment.
Yes. Justice A.K. Goswami, Justice Ujjwal Mia was there.
Was there, I forgot. Justice Kotoki was not there probably in that.
No, he was not there.
But this is after Muslim Mandal.
After Muslim.
After Muslim Mandal. Anyway, give it to us by Friday or Thursday.
Yes,
We'll pass the order here next week.
yes.
For your help, we'll list it on Friday. In the meantime, you give it to us. And Ms. Wajida, whatever, if you want to place anything, any judgment or whatever, you rely upon, just give it to us. We'll close the argument at this stage. Just give us the materials. For MS Al Wazir. Counsel appearing for the petitioner. And MS Al Reveal and HCC for the respondent number 1. Also heard Mr. G by standing counsel from department Assam for the respondent numbers 2, 3, 6 and 7. RK or R? R. Government Advocate Assam for the respondent numbers 4 and 5. List again on Friday for it.
This is probably, this was.
Further concept for further concept. Or doctor mentioned. Straight by the petition. List after answering for the petition and this will be the petty parties. That will be fixed by the list. Same one. 6 article mentioned. Seven. Oh, yes, yes. This cannot be some job. Eight article mentioned.
So put on
Nine mentioned.
9 mentioned.
Please, Lordship, can the matter be fixed after presentation?
এইটো মই ইয়াতে থৈ দিলো বহুত কৰিব আমাৰ মস্ত বান্ডিল আছিলে এফটি মেটাৰ্ছ বিলাক ইয়াত নাথাকিব তেতিয়া কালেক্ট কৰা বহুত কিবা কিবি আছিলে
I'll provide it. We have the bundles.
No, we have also collected some of the
Yes,
others.
yes.
It was there earlier where I was taking. In fact,
We have also provided some.
while searching in a particular matter, we found while just sitting with Justice Goswami, passed an order. It's not reported, but I was reading here. It was available here, but there are some issues. Anyway,